Like most countries in the SADC region and elsewhere, maybe in the world, Eswatini has legislations that regulate the conduct or relationships among stakeholders, that is, employees, employers, and the government. And the legislations which we often use are the Industrial Relations Act 2000, the Employment Act 1980 as an amended, a very old act, the Occupational Safety and Health Act, also quite old. In this presentation, I will focus briefly on the Employment Act 1980. As one can see that it is an old act, and will mainly talk about the Industrial Relations Act, the act which gave birth to labor consultants in Swaziland or Eswatini. The Employment Act of 1980 established the office of the Labor Commissioner, whose powers and duties in terms of Section 8 of the Act was to investigate and, where requested, conciliate on any question, on any dispute, on any grievance arising out of an employer-employee relationship. Labor disputes were channeled to the Labor Commissioner to resolve. Of note, the Act does not mention anything about representation when the Labor Commissioner handled complaints and conciliated workplace disputes. It seems the issue of representation was not an issue. The Industrial Relations Act of 2000 came into play in 2000. It established the Conciliation, Mediation, and Arbitration Commission, a structure similar to the CCMA in South Africa. The CMAC was to resolve disputes, and if the disputes were not resolved, parties would go to the industrial court or by consent to arbitration by the CMAC. These powers to conciliate were removed from the Labor Commissioner and transferred to the CMAC, which is the Conciliation, Mediation, and Arbitration Commission. The Industrial Relations Act came with representation of parties at conciliation and arbitration and at the industrial court. Section 814 states how a party may be represented, and Section 81 Part 5 states that, notwithstanding subsection 815, a party may be represented by another person in a conciliation proceedings. Parties to such proceedings agree to such representation. At arbitration, there is no need for consent for parties to be represented by another person. A party can be represented by any person if a party has faith in that person. The Act does not specify another person, who this another person is. Parties, especially employees, needed to be represented at conciliation, arbitration, industrial court. Employees and small employers could not afford the exorbitant fees charged by lawyers and advocates. There were people who were known by employees to be vocal in their unions when representing employees in negotiations and disciplinary hearings. They began to request these people to come and represent them at conciliations and arbitrations. These good Samaritans saw a gold mine and established themselves as labor law consultants. So mainly the consultants were ex-trade unionists and ex-human resource management practitioners. Labor law consultants in Swaziland are not regulated. As a result, most of them have no offices. Instead, they operate from briefcases. The fact that they are not regulated imposes a great risk to the public members or clients who use their services, in that oftentimes clients complain of unaccounted monies received by consultants on their behalf in matters handled by them. In the event of funds embezzlement by labor law consultants, the clients have nowhere in the absence of the regulator or body to report them for this impropriety. Another problem is that there is no code of ethics regulating the conduct of labor law consultants in the country. What do they do? Among others, labor law consultants chair disciplinary hearings, represent their clients at CIMAC on labor disputes, at conciliation and arbitrations. They appear or represent clients at the industrial court and giving legal advice on labor matters. Those who have done law or human resource management draft contracts of employment, draft human resources policies, conduct trainings on industrial relations and labor law. The fact that they are not regulated imposed a great risk to the public members or clients who use their services, in that oftentimes clients complain of miscounted monies received by consultants on their behalf in matters handled by them. In the event of funds embezzlement by labor law consultants, the clients have nowhere, as I've already mentioned above, to report them for the impropriety. Another problem is that there is no code of ethics regulating the conduct of labor law consultants in the country. They are not governed by any legislation. They operate willy-nilly. There is no controlling instrument. What are challenges? The lack of qualification is a problem because they fail to effectively and efficiently discharge their duties due to lack of the necessary knowledge and expertise, especially in a case which has complex legal technicality issues and where a labor consultant's counterpart is an attorney. Any individual gives himself the status irrespective of his qualification. Recommendations. It is recommended that a body or association be established to regulate the operations of labor law consultants in the country. That a labor law consultant should have a minimum labor law qualification as a prerequisite for them to represent people. It is recommended that a code of ethics be made by the body that is going to oversee the operation of labor consultants. Thank you.